Welcome. Thanks for clicking in. I want to welcome you to another important contract issue, one that is on the top of every buyer's mind. It's earnest money. And there are some huge misconceptions about earnest money and how you, as a buyer, are protected. Now, in paragraph 4 of the contract to buy and sell real estate, return of earnest money, it does say that if you terminate the contract agreement, the seller agrees to execute and return the earnest money to the buyer within 3 days. But it also brings into play paragraph 24, where it gets real dicey. And you, as a buyer, better know this up front because your earnest money could be delayed for up to 4 months. In addition, it states in paragraph 24 that the earnest money holder, the seller, is entitled to recover reasonable court costs and reasonable attorney fees and legal fees incurred in a lawsuit. This is not the same for a buyer. In the event of a lawsuit, you, the buyer, are not covered with court and attorney expenses by the seller, should you win the case. And because most earnest money figures are in the $3,000 to $5,000 range, that money is gone before you even begin. So the point is this: your real estate agent should cover this with you. If they don't, they're not doing their duty. If they say your earnest money is protected, they're not telling you the whole truth. And while most transactions that are terminated result in the return of earnest money to the buyer, that's not to say something could go wrong. And if you didn't know, if your agent didn't cover paragraph 24 with you and you lose your earnest money, you will be livid because you didn't expect it. The subject was never covered, and that's not right. Look, earnest money is probably the number one thing buyers are worried about, and agents have a tendency to say, don't worry about it, it'll be fine. But when they say that, and you then ask for the contract details, specifically paragraph 24.